Hello everyone, welcome to Adamya Academy YouTube channel. So today we will be discussing in detail about the various schools of jurisprudence which we have studied in little bit about them in previous classes. So let us start with our first school, which is Analytical School of Jurisprudence. Analytical School of Jurisprudence, also called as Austinian School of Jurisprudence, English School of Jurisprudence or Imperative School. So I have told you earlier that Analytical School is also called Austinian School of Jurisprudence. And what is the reason for that? The reason is that Austin was the founder of Analytical School of Jurisprudence. And why is it called Imperative School of Jurisprudence? It is because it considers law as it is. It means that we have to not look into the repercussions which will be there if we don't follow law as it is. So what sovereign has told is law. There are no discussions which have to take place regarding how law should be and what law ought to do. So this is what Austinian School of Jurisprudence tells us about. Then it is also called as English School of Jurisprudence. This also I have told you earlier that Austin as well as other propounders of jurisprudence were mainly based in English or USA. So we are studying jurisprudence as an international principle. So the proponents here are mainly of UK as well as USA. It is also called positive school and command of sovereign. So the famous theory which this Analytical School of Jurisprudence has given us is command of sovereign, which is backed by sanction. Sanction here means any obligation or any legal bindingness which a person has to follow if he or she is not working according to the law. Chief proponents are Bentham, Hart, Holland, Austin, Galson, and Salmond. So this is the very famous person because he is the father of jurisprudence. And of course we are discussing about Austin. So Austin is the father of Analytical School of Jurisprudence. Jeremy Bentham, he is the founder of positive school. So I have told you earlier that there is a difference between father and founder. A father is the person who introduces us to the topic, but it does not mean that he carries forward the topic. The founder is the person who actually carries the subject ahead. Law. Law can be divided into expositorial as well as censorial. Expositorial, what does it mean? It means that law as it is should be followed, whereas censorial means how law is supposed to be, how it should be followed. So I have told you one example, like whenever we go to see a movie, there are some how the movie should have been is a question before it is passed by the censor board. So the movie which is shown is how the movie is, and what it should have been was before censor board cut the parts of the movie. So this is what we can understand law also like this according to Jeremy Bentham. Basic theories of propounded by Bentham: utilitarian theory, pleasure and pain theory. So what is the meaning of pleasure and pain? In a society, there are many individuals and the individuals have to interact with each other. Let us take an example. If some individuals think that a person A has to become a CM and the other individuals think oppositely that the person B should be the CM. So they are thinking this because they have some pleasure and pain concept in their mind. They are probably thinking that if we get CMA, then job opportunities will increase in future. Similarly, if we get B as the CM, he may not be able to work for the job opportunities of the citizens. So they have a concept which is pleasure and pain concept. So this samely applies here also. What is hedonism theory? Greatest happiness in greatest number. I have given you an example of trolley. Like, for example, let us assume there is a trolley with 4 wheels, and the driver of the trolley is not able to control that trolley because the trolley wheels have been broken due to unidentifiable reasons. So, the trolley can go on 2 paths. One is path A and another is path B. Here, 2 workers are working in a construction site, whereas in path B, 6 workers are working in a construction site. So, what according to you would be the better way to go for adopted by the trolley driver? The answer would be, of course, he will move his trolley in the direction where 2 workers are placed so as to not to cause maximum damage or maximum deaths of the workers. So this is what hedonism theory states. But we should also remember that utilitarian theory as well as hedonism theory work hand in hand because both aim at the maximum benefit of maximum people. C point which Bentham has propagated is supporter and of laissez-faire state. It means that all the individuals should work efficiently in a state and they should have equal opportunities to strive for a better future. D is codification of law. According to Jeremy Bentham, there is a need of codification of law. So what do you mean by codification of law? It means that law is not just morals or just discussions. It is written law which the courts and various jurists they write, and in due process of lawmaking, these are enacted in the books. So codification of law is needed because let us assume, suppose I will give you an example. Let us assume that in Indian Penal Code, if there are no punishments given and only murder, theft, and various other crimes are just said that they are crimes, but do you think the citizens will follow those? No, because for citizens to follow that, they should have some legal sanction behind it. It means that they have to follow law not because it is laid down by some authority. They have to follow law because if they don't follow law, they will suffer punishment or penalty which will actually make their future a hell. Pleasure in religious, physical, political, and moral. So according to Jeremy Bentham, we have to strive, a law should strive for pleasure not only in one sphere of life or one sphere of society. It should strive for pleasure in religious, social, economic, political, and various conditions which are prevailing in the society. The next author is a very famous author, John Austin. He is the father of analytical jurisprudence. And I have told you the founder of analytical school of jurisprudence is Jeremy Bentham. Law is command of sovereign backed by sanction, ruled by intelligent people for intelligent people. So you have probably heard about the definition of democracy, what Abraham Lincoln has to tell about democracy. Democracy is rule of people, by the people and for the people. Similarly, Austin also tries to say that law aims to, or sovereign helps us to make us rule by intelligent people for intelligent people. It means that the people who are being governed are also intelligent and the people who are governing us are also intelligent. Consider a situation where the people who are being governed are not intelligent. It won't then there will be loopholes in the lawmaking. So, in this situation, what is in the modern society is that the people who are being governed are also intelligent, and the people who are governing us are also intelligent, so as not to create any hindrance in the governance of law. Law properly so called and law improperly so called are the two bifurcations which John Austin has given for understanding law. So, what do you mean by law properly so called? Law properly so called means that it should have force and sanction behind it. And what is law improperly so called? It means what historical and sociological school have to tell about law. They only go into the past, they treat society, they try to make interrelationship between law and society, but in their dictionary there is no definition of law, or no, in their dictionary there is no force or sanction behind their definitions. So law properly so called should have force as well as sanction, whereas law improperly so called, as given by historical and sociological school, have no force or sanction. Main elements of his theory. So the main elements of his theory are three, which are command, which is the first, sanction, which is second, and duty, which is third. And fourth one is sovereign, which in one line we can say command of the sovereign backed by legal sanction. There are certain laws which are not command but are still followed. So a very different idea which Austin wanted to promulgate was that the command of the sovereign should be followed, but it doesn't mean that the laws which don't have sanction behind them have no importance. They also have importance, but they have less importance compared to the laws which are given by sovereign and which have sanction behind them. So there are certain laws which are not commands but are still followed. For example, declaratory laws, law of repeal, and imperfect obligation. What do you mean by law of repeal? Law of repeal means if some law is not according to the prevalent conditions of the society, it needs to be changed for the betterment of the society. So, a new law is enacted in place of that old law. This is what law of repeal means. Imperfect obligation. What does imperfect obligation mean? A law is a law, but it has some characteristics attached to it. Some moral obligations are attached with the law so as the law is made. So the moral obligations attached to a law are the imperfect obligations which John Austin is telling about. Law of repeal, I have told you. So concepts ignored by John Austin are their several criticism of every propounder which we'll be learning and which we have learned. Similarly, in this situation also, Austin has also suffered some criticism in his theory. So, the first criticism is that he does not lay importance to customs because he considers law to be in a written form, which whatever sovereign has told will be the law, not what the law was and how the law has evolved. So he does not look into the customs. Immunities. He focuses on the concept that whatever sovereign has told is applicable to each and every person in the society. No person is immune from the sovereignty. The command of the sovereignty is supreme. No immunity to any person. Judge-made laws. According to John Austin, if judge make laws, then it's not the work of judiciary to make laws. Its work is to interpret the law. So according to John Austin, the work of making laws is given to executive or legislature. But whenever judge make laws, then he will not consider those laws to be laws. So this is what John Austin has to tell about judge-made laws. International law. He considers international law to be a soft law, which means that it does not have any legal bindingness on the different countries. For example, let us take an example of UN. You all have heard about United Nations treaties, agreements, conventions, which different countries sign in order to have friendly relationship and trade with each other. So let us assume that if there are 50 member countries and if a country A does not follow a treaty or agreement which it has done with country B, then do you think UN can do anything? Of course not. He will only tell country A that you should not do that thing, and also it will tell that your membership has been cancelled, but it can't make the country suffer punishment. So according to John Austin, international law is a soft law or a weak law. According to John Austin, morality does not have any place in law. So some things can be immoral but are legal, and some illegal things can be moral. So as to not to confuse between morality and law, he has bifurcated both and considered only law which is given to citizens by the sovereign. Third propounder which we will be studying is H.L.A. Hart, who belonged to Analytical School of Jurisprudence. His book is named as Concept of Law. Law is a system of two types of rules according to H.L.A. Hart. First, primary rule. Second, secondary rules confers powers, and union of both is law. So what do you mean by primary rules and secondary rules? Primary rules are the unofficial rules which are binding because of popular acceptance, such as rule of kinship, family, sentiment, etc. One may think of a situation when the generations of the family are following a particular rule or law, and they are not thinking that in the modern society will that law or will that custom fit. So they are just following it for the sake of following through generations. So this is what is written in primary rules. So the defects which we can see in these type of lineage following of law is that first, it is uncertain. It means that once the law is promulgated, once the custom is followed, it does not mean that it will be followed. A generation may say that we are not following it because of XYZ reasons. Static character. As I have told you that that law will have static character and will not be flexible because the generations will follow it because their ancestors have followed, not because it is rational or it is reasonable. They will follow for the sake of following. Thus, it has a criticism. Third is insufficiency. As the law which is being followed without looking into the rationality or reasonableness will have some insufficiency in it. It means that in the modern context, that law may seem stupid. So these are the criticisms. Secondary rules. They are power conferring which enables the legislators to modify policy and remedy primary rules. Secondary rules are the rules which have actually become law. They don't look into the custom or morality. If the legislators have passed the law, then they have become law. So this is followed. Criticism of Hart. Ajay Hart has also got a criticism in his theory, and in his book, The Concept of Law, he has written about law, but he does not mean to say that morality should be looked into. He meant to say that law should be regarded as law and should be excluded from the principles and ethics and morality. The fourth propounder which we'll be studying is Kelsen. He gave the famous theory, pure theory of law. Law is normative science, those norms which have character of legal norms and makes acts legal or illegal. So pure theory of law means that the law should be away from religious matters, political matters, social matters, economic matters, etc. Law is normative science. According to Kelsen, law is a normative science. It means that there are some basic rules or basic guiding principles on which law is founded. So, like for example, the Constitution of India is the basic norm on which our country is being governed. Those norms which have character of legal norms and makes acts legal or illegal. Let us assume that there are two acts, Family Act as well as Constitution of India. So, in the case when when ambiguity arises between an article of family law as well as constitution law, so what do you think? Which law will prevail? Of course, Constitution of India will prevail because it's the supreme law or it's the basic norm governing the society. So, whenever there is a conflict between a supreme law or norm, then it will only prevail which is supreme. Similarly, we can take Constitution of India versus family law is example 1 and example 2 family law and by rules. If their conflict arises between family law and by rules, so what do you think will prevail? Of course, family law, because family law is more codified than the by rules or bylaws. So these are the two examples which I have told you. Norm is equal to rule formatting or prescribing certain behavior. For example, Constitution of India gives us certain rules or guiding principles. For example, let us take an example of Article 21. What does it state? It tells us about right to life. It means that right to life and personal liberty can only be taken away except procedures established by law. Norms are of two types, moral norm as well as legal norm. Rules without sanction, hierarchy of norms having sanction. Moral norm is not looked into in the present scenario, whereas legal norm is looked into. So, in the Constitution of India, will it follow in moral norm or legal norm is the question. The answer will be, of course, legal norm because it is written and it is not based on the moral principles, rather it is codified and thus has become a legal norm. Important concepts of law given by Kelsen. Pure theory. Law must be free from all social sciences, that is ethics, history, politics, sociology and economics. This I have told you. Second, pure sciences of law. He defines science as a system systematically arranged. So pure science of law means being rational. What does science tell us about? Science has various inventions, outcomes, and it studies about the relationship of different parameters with each other. So we study rationality in science. So pure science of law, as given by Kelsen, also studies about the rationality of law. Normative science. What ought to be the law? What do you mean by what ought to be the law? It means that Carlson not only thinks of the present generation but he also considers past generation as well as future generations. He thinks that the law should be in accordance with the needs of the past as well as future generations, including the needs of present generation. So what ought to be the law is that he's thinking about future as well as past law. Grunge norm theory, as given by Carlson, is a very famous theory. It states about the paradigmatic structure of hierarchy of norms which derive their validity from the basic norm. So grunge norm is the basic norm. For example, in the previous classes when we were discussing about the questions, one question was that which is the grunge norm of India? So the answer was that Constitution of India. Because Constitution of India gives us hierarchy of norms. For example, in matters related to the family members, it has given us family law, whereas in matters related to marriage institutions, it has given Hindu law as well as Muslim law. So these are the different laws which are based on the grunge norm or the basic norm. Superior norms having control over subordinate norms. Superior norm example is Constitution of India, and subordinate norms we can give example of family law, Hindu Marriage Act, etc. Holland. What Holland has to tell in analytical school of jurisprudence. Law is general rule of external human action enforced by sovereign political authority. Holland has to say that the law should not only look into the internal needs of a human being, it should look into what they are behaving in a society when they are interacting with each other. So it's a general rule of external human action enforced by sovereign political authority. So what do you think is the sovereign political authority in the modern context? It will be the legislators or the law-making bodies which are making law, which can be the supreme legislation as well as the state legislatures. All other rules are not merely the analogy, prepositions, and not for actions. According to Holland, irrespective of the supreme law, we should also look into the rules which are there so as to for proper governance of the society. He also says jurisprudence is formal science of positive law. This is one aspect in which Holland and Austin had different views. As I have told you earlier that Holland was a disciple of Austin. So Austin told that what is law? Law is positive law. But Holland detailed the definition given by Austin and told law as formal science of positive law. What does the word formal here means? It means that citizens should also know that the law which is made for them, is it rational or irrational, and what are the stages with which the law has been passed. So in case they think that the law is not accordant to the needs of their, then they can approach the sovereign or the system and tell that law should be changed. But it is for the sovereign to think that or to give the answer that whether the law should be changed or not. So it all depends on the sovereign, but the citizens should know how the law has been made. He criticized division of law into general and particular. He uses the word science because it deals with the relation of mankind having consequences, not rules that create those relations. Various principles of science have consequences in the future as well as present generation. For example, let us assume a recent example which is flooding in the newspapers right now, which is about artificial intelligence. Do artificial intelligence have sufficient laws so that if anything happens in future, it is able to take note of that. So till now, artificial intelligence is an evolving subject which needs to be thought further of with regard to the punishments or any penalties which if or non-followance of the artificial intelligence rules. Salmond, his book is Theory of the Law. He mentions law as science or civil law, which means the knowledge of the law of the land. So, in the previous class, I have told you that whenever Salmond comes, we have to know a single word. The key word is civil. And civil law has many bifurcations which are systematic, historical, and critical. Civil jurisprudence takes into account the past laws, past legal systems, as well as present legal system, as well as future legal system. It means that, let us take an example of a prevalent happening which used to be there in a country A, which was racism. So, by learning from the racism concept, we have learned, but taking a look at the racism concept, we have learned that racism is not good because the society has progressed so far. So in India, if someone suffers from racism, will that be a law? Will that be taken note by the law? Of course, that will be taken note of because we have studied past legal systems and we are now knowing that what were the mistakes which past legal systems are not to be repeated in the present legal system. And if present legal system also have some loopholes or mistakes or some laws which are not according to the needs of the society, then of course we have one option that the future generations could be better than the present generations. So this is what we have studied about the analytical school of jurisprudence. We have studied analytical school in much detail and have covered all the points related to it. But I would recommend you that you first read all the slides which I have taught in the previous classes in short about the various schools. So in next class we will be studying about historical school of jurisprudence in detail. Till then, revise and stay tuned. Bye.